Hello, welcome to Cello Law Webinars. Let's see when people start joining, and we'll get started shortly. I hope you have your chai cup with you, or your coffee cup, or whatever it is that you prefer to your drink of choice. And let's see, people are slowly trickling in. I hope you all have had a good week. We've had some beautiful weather, so you've had some chance to go outside and enjoy it with your family or your friends. And I've started going on long walks in the morning, which has helped me rejuvenate for my day, although I didn't get to do it this morning. Had an unexpected call, but I hope to do it this afternoon. So let's see as the folks are joining, and we will get started. So welcome to the Cello Law Weekly Webinar. Today we're going to touch on some really interesting topics, issues that deal with that you deal with while your AOS is pending, and also strategies for pending and future applications. And we're also going to touch on, is the visa backlog dead in Congress, or is there a way in which it can be resurrected? So, going to be some interesting topics, and as always, we'll have Q&A at the end. And I want to remind folks, please place your questions in the Q&A box and not in the chat box. It just makes it easier for us to kind of see, respond to people as they post. So we're able to get all the questions answered. So let's get started. As I've stated before, there are different ways to connect with us: Facebook, Twitter, Instagram, YouTube, LinkedIn. And I love connecting with you, so please connect with us on one of our platforms. It's great to hear from you and to hear about all the issues that you're dealing with. That helps us better plan what agenda items we have, because we want to make sure this is for you. So we want to make sure that we develop content that is critical for you to use as a tool in your immigration journey. So if you have missed, where is, oh, it's supposed to be closed captioning. I don't know why. Oh, there it is. There we go. I wanted closed captioning so that in case I talk too fast, folks can hear what I'm saying. So if you missed any of our video recordings, please check out our YouTube channel. It's we're uploading stuff all the time, and today's my day to record, so I'll be recording some additional materials that hopefully are useful, and there'll be 15-minute bits. It's called Immigration in Brief, 15 minutes or less, that we will highlight, different topics and explain it to you. So hopefully you will understand it better and can make good decisions as a result. Comment if you like the content of our YouTube channel, share it with your friends, and of course, subscribe. And when you subscribe, what happens is you will be alerted every time we post something new. So, Department of State predictions. So let's get started with that. Oops. There we go. Now, we went over this a couple of weeks ago, but I think there is still a lot of confusion as to, and worry that, the numbers that are there or will be available will not be used. So let's go over some of the things that Oppenheim said in his last visa bulletin predictions. And when he has his next meeting, we will publish information about, the latest, his latest updates. So keep in check for that. So Oppenheimer said that family usage is still low due to the overseas processing limitations. I mean, COVID is impacted differently in different countries. And so the ability to, really have all the consulates open up at full capacity is limited by that. And so that's why he predicts rapid advancement of employment-based categories. EB1 is going to remain current throughout the year. And they said both India and China should see rapid movement going forward. Now, as a disclaimer, he doesn't have the figures on the EB2, EB3 ground downgrade cases yet. So that's not included in his predictions. I mean, they have an idea, but they don't have the exact number. So that's what I think he's going to talk about in his next, roundtable discussion. So look out for that. If you, like I said, if you connect with us on various platforms, we'll make sure to publish it. So you'll get that hot off the press. Now, what did his visa numbers include? So one of the things he explained is how are the final action dates calculated? And the example he used was, let's say, as a house owner, you've got a budget. You've got the money coming in, your salary or your spouse's salary, but the money coming in and your expenses. So you allocate your money based on what's coming in versus what needs to be expended. And he says that's what they usually do to find out the final action dates. It's the usage rate. They put a certain percentage aside for emergency cases and future expectations. And then they get reports from the unused numbers from the overseas posts. That's how the final action dates are determined. And just reminding everybody, please, if you've got questions, put it in the Q&A and not in the chat, and we will get to that at the end. What's the difference between the two filing charts? Now, final action date means that your priority date is current. And that locks in your, if you've got a child that's going to age out, final action dates will lock that in. Whereas the dates of filing is just to pre-review your application, whether it's for overseas processing or whether it's through an adjustment. Some people call that pre-adjudication, so they review it. They're not going to make a decision on that because they will not make a decision until the final action dates are current. And again, it does not preserve CSP. It does not protect your child's age. So what is the spillover between EB2 and EB3? So you remember that of the overall 140 plus thousand employment-based visas that are allocated, there's a per country cap, right? That's what we're trying to get rid of, but there is a per country cap. So there is a 7% per country. So annual limits by a country are subtracted from the overall annual limit. So the countries that use the most immigrant visa allocations are the ones that have the greatest backlog. So they will first assess for whether it's EB1. Let's say EB1 is not fully utilized per country. Then the EB1 will spill over whatever's left of that into EB2. If EB2 is not fully utilized, then that spills over into EB3. And so they reallocate based on the earliest applications. So that's how the spillover works. And a lot of people keep asking us, why is EB2 India moving so much slower than EB3? Well, Oppenheim addressed this too. He said there were fewer EB3 applications that were ready to be processed immediately. So the date is advancing quickly to increase demand, to increase EB3 applications. And he was saying that, you may see rapid movement of EB2 in May of this year. Visa bulletin predictions. You know, the dates will start accelerating. He predicts 247,000 employment base, but that's without the calculation of the downgrade. So I think his next set of predictions will be more precise. So look out for that. And let's talk about the USCIS utilization, because remember, Oppenheim is Department of State. Visa bulletin comes out of Department of State. It's interconnected with how USCIS is processing them. So you kind of have to look at that in conjunction to fully understand how that is being processed. And so what I would, before we get on to that, I wanted to ask attendees, as we're having our chai time, how many of you raise your hand if you're tea drinkers? How many tea drinkers do we have? You know, I never drank tea until I moved to India, and tea in the United States, I mean, you know, you have the green tea, the herbal teas, which are all good. I love those too. But to grate some ginger, put some ilachi, boil it on the stove, then add your, I don't drink milk anymore, almond milk, and have it boil for some time. And having that chai is the best thing in the world. So how many of you, raise your hand if you're coffee drinkers? How many coffee drinkers do we have? Not as many. Well, great. It's whatever you need, whatever gives you that caffeine boost, right? So let's go on to visa predictions. What does 2021 look like? COVID still impacts, like I said, overseas posts. The unused family numbers, so that really impacts family-based. Vast majority of family-based are through the overseas posts. And so if those are still remain low, they'll be added to the employment-based side. And so the family annual limit is 226,000, and they predict that the employment will be 275,000. And when asked whether all of them would be allocated, everyone's worried that they won't be utilized. Oppenheim said that they are going to try to make sure that they are. Visa bulletin prediction has employment-based utilization increased. What they said was there were a lot of new filings in October and November that increased processing. So they think the utilization rate by USCIS, that means what that does is these are petitions that are being processed will increase in the second quarter. So they will know what's in the pipeline. And once they know what's in the pipeline in terms of numbers that are going to be converted to ones where the priority date is current, they can then assess how they will allocate the 275,000. So how the USCIS is processing them, how quickly they're processing them, will reflect directly on the visa bulletin dates. I hope that makes sense. So last year, 122,000 unused family member visas. And typically, you know, employment is about 145,000 each year. So they predicted in last quarter, it was 262,000. And remember, USCIS, their fiscal year runs from October to October. So they predict this year it'll be even more. So we can see, you know, like I said, vast movement, and hopefully some of you getting your permanent resident status with the final action dates being current. Now, DOS did note that the resumption of visa services would occur on a post-by-post basis. Like I said, it just depends on how COVID is impacting that particular country. From what I understand right now, Brazil, it's really bad. And in India, it's also, the COVID cases are on the rise. So with a large number of COVID cases, they're not going to operate on the regular full speed ahead. So it's going to be on a limited basis. What are pre-aegided cases? Remember, I talked about that a little bit before. So when you do dates of filing, people always think that, okay, because my priority date isn't current, are they even going to look at the adjustment? Yes, they do. They review it, and your work authorization and your AP and all that get processed, and they do a review of the application to make sure that it has everything it's supposed to have. So, for example, there were a lot of people who filed in October and November, and they weren't able to submit medicals because of the time frame. Well, when they review this now, if they issue an RFE, you'll be able to get that in before the final dates are current. DOS operational updates. We told you we'd have some updates for you. And so the DOS is working to reduce the backlog on visa applicants waiting for an interview. Consular sections have the capacity of prioritizing immigrant and fiancé visas, and immigrant visas previously refused because of the president's proclamation. So we will be able to see that going forward. And I am, as I do every week, launching a poll. I hope I have it set out as anonymous, so you'll be able to respond to it without anyone knowing, who the person is that responded. So please respond to the poll. Just some questions on how social media impacts your attainment of immigration knowledge. And that helps us so that we can better our processes. So I really appreciate you responding to the poll. Thank you. So next, we have embassies that process non-immigrant visas are prioritizing travelers with urgent needs. Remember, there was this backlog. March 31st, they started allowing non-immigrant visas to be processed again. Foreign diplomats, mission critical categories of travelers, some student exchange visitors, and then the temporary employment visas. So one of the things you can do as a tip from me to you is still, if you have to apply for a visa abroad, why don't you still make the emergent need argument, even though it's not required, because so that you can get prioritized within that line. And again, remember, each post is operating on a different capacity. The geographical COVID-19 proclamations are still in place. And these are just because of the countries that have either a large number of COVID cases, or there may be issues with reporting. So China, Iran, Brazil, UK, Ireland, South Africa, and the 26 countries in the Schengen area are still under that proclamation. So that's the only one that's in place, but it's COVID-based, not immigration-based. So legal challenges to the geographical visa ban. There are challenges. There's so many lawsuits still out there, and they're still processing them on the EAD delays, on biometric delays. So these legal challenges haven't stopped just because you have a new administration, because they still want to make sure that some of the, I guess, the legacy of President Trump gets, they're able to address that and bring it to light. So the lawsuits state that the interpretation is unlawful, and the president doesn't have the authority to instruct consulates to suspend visas. And that's what they had said earlier. The president he has wide discretion in instituting restricting the entry of people, but he can't tell consulates not to process applications. So that is what they are arguing. The entry bans based on presence should allow for entry after the individual has remained outside the designated countries for 14 days. So if you're saying that COVID is impacting your ability to allow someone from Brazil to come into the US, if the individual from Brazil goes to Argentina or some other country for 14 days, they should be able to process and come back in at that time. So these are some of the things that are issued with the COVID-related travel bans. And as I stated, the pandemic is really affecting pending petitions. DOS acknowledged there's 473,000 immigrant cases pending at the National Visa Center. And that doesn't include cases at the embassies and consulates that haven't been interviewed and that are still gathering documentation. Now, here is what I wanted to, I think all of you would be interested in is there any hope for any immigration legislation to address the visa backlog? And I think there is. As I told you, for those who haven't joined our webinar before, and that makes me want to ask the question, another question for a raise of hands. Who is attending the webinar for the first time? Raise.
And I look forward to seeing you this Wednesday.
Oh my gosh, what is that in the background? Okay, so how many of you have raised your hand if this is your first webinar? Yay, well, welcome. Thank you for joining. And I always appreciate the ones that attend every week and take time out. So I wanted to tell you about fast track budget reconciliation. So what is the big problem? Really, you know, the Democrats have the majority in the Senate. And you don't need more than a majority to pass a bill. The problem is the filibuster. The filibuster is a way in which the minority party can oppose any bill, and they can, you know, stop the vote by using this process. The only way you can overcome a filibuster is two ways. Number one, you have to have, instead of just a majority, you have to have 10 more Republicans sign on to the bill. That's one way. The other way is through budget reconciliation. Budget reconciliation, if it's raised, allows bills to pass with just a simple majority. Now, budget reconciliation, it cannot be incidental to the budget. It has to have either a revenue or an expense impact. Now, usually the president is not granted a lot of those. But the Biden administration raised that, you know, they've already passed one, you know, the latest COVID relief was passed through budget reconciliation. So the Biden administration asked the parliamentarian is the individual who has been placed, and this person was appointed in 2012, that reviews the rules of the Senate and makes a decision, and it's binding on the Senate. So they asked the parliamentarian, I think we have one more. And the parliamentarian said, I think you have at least two more for this calendar year. So they have two ways in which they can take a bill and tie it to either income or expense and pass it with a simple majority. Now, there's certain bills that definitely would not qualify for a budget reconciliation, like the Voters Act, Voting Rights Act. The transportation bill could get through on budget reconciliation, and immigration bill could get through on budget reconciliation. So that is really something I'm working on with. I told you that I've been, I was selected to be part of Ap 100. That means 100 Asian Pacific Islanders that are helping to shape policy for Congress and the administration. And one of the things that I'm looking into is how to weave some of these bills, including the visa backlog, into the budget reconciliation bill. So before I get into a contest, you know, if any of you want to have a Chella mug and spend 30 minutes with me on a chai time, we can talk about your immigration. We can just chat about whatever you like. So we will be giving you sending you a mug for your tea and coffee, along with a $20 Starbucks gift card and 30 minutes where we can have tea together. So how do you enroll in this? Send an email to 3 of your contacts telling them about our webinar/YouTube channel with the link to subscribe. And then also invite them to our Telegram group. Like I said, you got to make sure you send the links, and I'm sure my team will put the links up right now for you if you on the chat, so you can see them then. And blind copy info@chellalaw.com. And when you do that, you will be enrolled for a drawing that will, like I said, will send you the Chella mug, the Starbucks gift card, and we'll schedule a time that's convenient for you so you and I can chat for 30 minutes on whatever you like. So let us know. Usually my consultations are $250, so that's pretty nice to be able to have some private time with me, but you don't have to talk about immigration if you don't want to. You can talk about whatever it is you feel is necessary, but I hope you will enroll. Again, you send an email to 3 of your contacts telling them about our webinars/YouTube channel and our Telegram group with the links attached, and blind copy info@chellalaw.com, and you will be automatically eligible for our drawing, where we'll pick out someone, and I'll do that on YouTube. So if you're subscribed to our YouTube channel, you can see it real life, and we'll announce the winner next week. So I hope you will join. And finally, we're going to get ready for our Q&A to talk about your strategies for what's coming up. As I've said over and over again, if you have not started your PERM process, your permanent resident process, this is the time. This is the time. If you have and you're already in AOS, and when you downgraded, you did an amendment instead of filing a new EB3 petition, you may want to think about starting the process and doing an EB2. You can retain the priority date, and that way you have 2 approved I-140s that you can use to interfile for your adjustment, because these numbers are going to move. But unless you have the tools and mechanisms in place to leverage this opportunity, you'll be shut out. And so, they say opportunity only knocks once. The postman knocks twice, but opportunity only knocks once. So you don't know when this may happen again. So you want to leverage that. Again, if you haven't joined us on our Chella chat forum, please do. The links are here. We have one for H's, H4s, AOS. We talk about everything in the Chella chats, H1Bs and H4s. And then we have one specifically for E3s. What does this do? Well, first you get a community. That's what we're trying to create. We're trying to create a community where we can talk about, our immigration problems with other people that are going through them together. And we're here, my team and I chime in all the time to give everybody guidance. So it's a really good way. One of the things I loved about the time I spent in India, when we were in Mumbai, we lived in a flat in Santa Cruz West. And so no one would close their doors. I mean, it was an anathema to me, having grown up in the United States. And people would have their tea, they'd go and get groceries, and then you're talking to your neighbor, and I'm having a problem with my servant, or I'm having a problem. I know my maid, but in India, they're called my servant. So excuse me for that. But, or I have this issue, you know, this family member is giving me, but it was a community where everyone got together and you got support from one another. I love that. And that is what we're trying to create here, a community of people who sip some tea, talk about their problems, and try to come up with some solutions to make their lives better. So join our community. As we said, there are a number of ways to connect. Check out our YouTube channel and please subscribe so you can get our updates. And if your question doesn't get answered, or there's something very specific you want us to talk about on one of the webinars, or you know, you've got to send us documents because you need us to review because your question is complex, email us at info@cellolaw.com. My email is lchella@cellolaw.com, but I'm going to tell you that I get hundreds of emails. Info goes to several people within the firm. So what does that mean? That means your question gets answered much more sooner than it would if you sent it to me. So info@cellolaw.com. And we're going to get ready for our Q&A. Before I do, I wanted to ask one more question. How many of the 48 people that are logged on today, how many of them are women? Can the women raise their hands and tell me how many women do we have on this webinar today? Well, I am going to start another Telegram group just for working women, because there's a lot of issues that, especially culturally or otherwise, that women have to deal with in balancing work life. So it has nothing to do with immigration, but I wanted to find a resource where we could all talk about what we can do to make sure that we do some self-care as we're taking care of, because women are usually the primary caregivers in every family. You know, it's kind of a support group for women. So look out for that. I'll have information on that next week. And we're going to invite Shaker Chella to join us so we can have our Q&A. Hello, Shaker. I can't hear you. You're on mute.
Okay, first rule, unmute yourself. So
unmute yourself.
Good afternoon,
exactly.
Everybody. Nice to see you, Lakshmi, and nice to see you all. Let's start the afternoon, and we'll start with Mr. Kishore. So, hello, Lakshmi. I have a question for you regarding H1 transfer. My H1 got approved previously with a cap subject employer in lottery process, and now planning to move to cap exempt nonprofit organization employer. In future, if I have to transfer to cap subject employer again, two questions. Do I need to go through the lottery process again? Will there be any issue for H1 transfer? And he says, my I-140 has been approved with first employer.
Okay. No, well, here's a couple of things for you to know about cap exempt. Number one, once you've been selected for the cap, and if you're already in the country, there's some cases where a person never entered the United States, but I think we were able to overcome that issue. But if you're already in the US, once you've hit the cap for at least a 6-year window, you're not subject to the cap. The other thing is, if you're on cap exempt, do you know that you can do a concurrent, if you're eligible and you have the time, a concurrent cap subject H-1B, even though you're cap exempt? So that may be something also you want to think about.
All right. Next one is from Nizar. Thank you for your webinar video related to how to call USCIS. It helped, and I contacted them to find out the status on my I-485, I-765 downgrade application. As many getting fingerprints appointment, and I did not. But I was told that my fingerprints are already there with them and not required to collect again. Is that possible? Last I went for stamping in 2014. Also, they told me to wait for EAD to process, as the processing time is 11 months. Interesting.
Well, I know there was a period that they were collecting, they were doing some biometrics even at the port of entry. I don't know if you've ever had to do that, or if you've ever had an EAD recently through F1 or on an H4, but that would be pretty much the only way they would have captured your fingerprints. I mean, you would remember somebody fingerprinting you. So I think that is very interesting, but you know, we'll have to see how that played out. I'm glad the YouTube video for how to contact USCIS was helpful. And Mac, if you could put that YouTube video up again, just in case there's somebody attending today that needs to contact USCIS, they could find it helpful.
All right. Next one is from series. My visa priority 10/18/2016 and is with my previous employer as Eb2 category. Do you foresee me getting green card within the next 1 year?
2010 under EB2, there is probably really good likelihood. We'll know more when the May dates come out, and with Oppenheim's next discussion on his predictions, because the last one didn't include the downgrades. And so I think once we have those two numbers, we would probably be able to make some sort of assessment or some sort of prediction on what the situation should be and when you should be current. But I would imagine with that type of priority date, you are probably in good shape.
All right, next one is from an AA, anonymous attendee. EB2 March 2010 priority date, filed I-485 March 2012, changed employer 2013, and filed AC-21 back then. No RFE since then. My employer attorney is not willing to send medicals or I-485J proactively. Is there a way to trigger RFE on my case? What are my options?
That's so stupid. I don't know why people wait. I would rather do it proactively. That way you don't, you're not going to, you could probably get an interview, especially with your dates. But what you may want to do to trigger it is Mac uploaded the how to contact USCIS. Contact them and tell them, hey, I didn't submit my medicals. I didn't submit my I-485J. When can I expect an RFE? And that will make them kind of check it, and maybe you can get it triggered that way. And so then, your attorney would then have to respond. And I want to remind everyone the poll is still up. So if you haven't responded to the poll, I would really appreciate it if you would.
Okay. Next one is from Sri Kumar. My employer comes under essential services provided by the U.S. Department of Homeland Security during this COVID time. Can I project this as a reason to expedite my EAD, 485 based and or 485 application? My spouse works as a contractor consultant for the same company. Can he project the same reason to expedite his EAD, 485 based and or 485 application?
See, the problem would be you can try. I mean, there's never harm in trying, but you've got an eligible work authorized status. So usually the emergent need is when your work authorized status is going to expire or you have an issue with continuing employment. But because that's not the issue, just because you're essential services doesn't mean that they, essential services comes into play, especially when people couldn't visa process and they would have to demonstrate there was an emergent need, and that was the way in which they could get a visa, because they couldn't provide those services if they weren't in the country. Now you're here in the country with a work authorized status. So I think it may be difficult, but you can try.
All right, next one is from an AA. Thank you so much for creating a good space for internationals. Good one, thank you. My STEM opt card, STEM OPT card expires in February 2022, and I didn't make the first lottery for H-1B this year. My company is looking into also applying for a perm for me. What if my OPT EAD expires while the perm process? Can the company still apply to green card? Can I continue to stay in orphan visa without EAD or OPT? What are the other options to keep my status?
What country, where were you born? If you can tell me that.
Whenever your attorney is asking a question, please respond in the chat so that I can immediately get to know what the response is and I can convey it to her. If you would put it in the Q&A, then I got to go all the way down. So that's my suggestion for all the attendees. So let's see what your response is in the chat. Which country you were born? Is that what she's asking? Ethiopia.
Oh, fantastic. So perm shouldn't take that long. I mean, we've got John Milburn in our office is just phenomenal with perms, and Kara can tell you what the current processing time of the perms are, but he's really good at crafting the job description. Knock on wood, he hasn't gotten any audits. And so, once the perm is approved, since you're from Ethiopia, you can file your I-140 and 485 at the same time, which means from filing that, you can get your EAD within, 5 months of that filing. So you would not have to change to another status or worry about not being selected for the lottery. In fact, we do it, 9 months. So we actually encourage our clients, when they have someone that is not from India or China, because there's a backlog, or ones that are not affected by the visa backlogs, to not only apply for the H-1B lottery, but concurrently apply for the perm, so you're not losing any time. So if you can get them to get started, and if you want them to talk to us, we're happy to. We will not charge to speak to them, and we're happy to aid in that, but he usually can get a perm filed. I think the prevailing wage is what's taking so long, because you got to get a prevailing wage with DOL, and they'll correct, my team will correct me if I'm wrong, but I think it's 9 weeks, 9 to 12 weeks. But there's certain steps that you can take prior to getting your prevailing wage, so that you can file your perm quicker. Once you file your perm, it takes 9 months to adjudicate. Once the perm is certified, you file your I-140 and 45 at one time. So Kara is saying that it's about 4 to 5 months now. So you want someone who is going to be quick in getting your documents and the prevailing wage, getting that going, so that you can file quicker and you can get a decision quicker, and then you can file your I-140 and 45 at the same time. Good luck.
All right.
Shaker, do you have your cello log mug?
I don't have the mug, but I will get one. I'm just seeing the chat. Somebody posted a question in the chat, And I'm requesting everybody to please post in the Q&A. I'll take the question on the chat in the same chronological order based on the timestamp. Ram Chandra is next person. Hi, thank you for helping the community. This is Chandra. My PD is March 2012. My EB3 140 is with employer A and ported to EB2 with employer B. And then company A acquired, merged by company B. As my EB3 I-140 is active, recently in October 2020, GC filed using supplement J with employer B signature. Did not file I-140 amendment. Will it cause any issue for I-485?
Yeah.
I also have EB2 I-140 active. Could you please advise what are my options if 485 denied with EB3?
Right. So anytime a company, there's an acquisition, it becomes a successor in interest. And he said company A acquired company B.
Pardon?
Did company A acquire company B?
A acquired, merged by company B.
Okay. If A acquired company B, then you have to file an amended petition. And what you can do is file amended petition for your EB3 and also file one for your EB2. If your EB2 was with company A, if your EB2 was company, well, with company, if your EB2 was with company B. And so if you file two amended, then you won't have any problems with your I-485, but you must file an amended petition. And if you need information on that to send to your employer, email us at info, and I'll send you my memo on successor and interest. And if you need me to talk to them, I'd be happy to talk to them.
All right, this is my cello.
All right.
Looks good.
It's a pretty heavy mug. I was going to say, if you didn't have a mug, you can always enroll in our contest. And
yeah, a very heavy mug requires a heavy material also.
Right. So, you know, you get some exercise for your arm as you're drinking the tea.
Heavy beverage of your choice.
Yes.
That's what I was trying to say. Anyway, it's afternoon. It's happy hour somewhere. All right. Next one.
I'm only drinking tea and coffee. Do not listen to what our moderator is saying.
Next one is from another AA. Hello, I moved from client A to client B within the MSA location. So we did not file the amendment petition. Question is, what will happen at the time of my next extension if my employer forget to update the public access file about my move to client B?
Well, the USCIS is not going to, they're two separate issues. The USCIS will not know whether, because they're, you know, the public access file is not needed for the extension. If you've changed location within an MSA, within the same MSA, or within commuting distance, and commuting distance is different based on localities. What's reasonable for commuting in Richmond, Virginia may be different than what's reasonable for commuting in San Francisco. So they're not required to file an amended petition, but they have to post at the new location. So it's more of a compliance issue. If they are audited, and we are seeing an upsurge in audits, you want to make sure that they post at the new location for a 10-day period and put that in your public access file. But that, if they don't, that's more of a sanction for them and not of you or your status.
Okay. Next one is from another AA. Lakshmi Garu, if we take a health insurance through Obamacare, healthcare.gov, does it affect on GC process? I mean, as it comes under public benefits.
There's only a certain number of benefits that are precluded. And I think that there have been challenges to the public charge on public benefits. So I think that is a change in process. But I think we did a YouTube video, Mac. If you've got that link, you can put that up on what are the precluded public benefits. And enrolling in Obamacare was not one of them. It's subsidized by the government, but you are still paying for it.
All right. This next question is from Amit Pandey. Looks to me a new attendee. Welcome. I greatly appreciate webinar and answers that you give to our questions. And I don't see any question, but thank you, Amit.
Thank you, Amit. And if that's the case, please share our YouTube information and our Telegram information with some of your contacts. So like I said, we can grow our immigration community. So
Yeah, I'm just trying to see if he has a question down, but I don't think so. But thank you, Amit. You're welcome to pose a question, but appreciate your gesture. Next one is from an AA. I wanted to ask, I traveled on AP due to emergency reason and started working with same employer on existing H-1B. My downgrade I-140 is pending. Should I file H-1B amendment to gain back H-1B status in case I-140 is denied?
no, number one, and this is for everybody, you could try to premium your, if you filed in October or November, try to premium your I-140 for premium processing. If they don't have the perm, we are finding that the vast majority of cases that we've upgraded to premium processing, they have the perm. But if they don't have the perm, you don't lose anything. They'll send back your fees, but at least you've tried. So that's number one. Number two, you can travel on AP, you can travel on your H-1B visa. And as long as you are working for your employer and not using your EAD to work from somebody other than your H-1B employer, you're still in valid H-1B status. So you don't need to file an amendment. You're in good shape. Don't worry about it.
All right. The next one is from Heather McKenzie. Looks like a new person. Welcome. Have you experienced extreme delays for AOS cases transferred to NBC? Or is it NBC? NBC, where the EAD travel doc is not being issued within the 90 days.
Oh, she's talking about the Nebraska Service Center, NSC. Because if you filed an AOS, it would not go to NVC. It would, because NVC is only for consular processing. So you're probably saying that your case was transferred to the Nebraska Service Center, and no one's issuing anything within 90 days. There is an exorbitant amount of delays, both for AP as well as EAD. So, Mackenzie, I wouldn't worry about it. We posted earlier how you can kind of call and, find out about the status of your EAD and AP. So please utilize that, because I feel like sometimes if you kind of bug them a little bit, it reminds them that your case is out there and it may help.
Yeah, how much time do you have?
I have, how many questions do you have?
About 20 questions.
Okay, let's go.
We'll just stop taking newer questions then.
Mm-hmm.
Okay. So appreciate everybody for, posing your question. Just hang around. I'll take the questions that are here. And if you didn't get a chance, please do send an email to info@shalawlaw.com. Be glad to reach you very soon or shortly. All right, let's go to the next. AA, if I'm not in US, living in another country, when priority date becomes current, how much time is given to file for GC via consular processing? Is it required to have a job in US at the time?
Can you repeat that again?
If I'm not in United States, living in another country, when priority date becomes current, how much time is given to file for GC via consular processing? Is it required to have a job in USA at the time?
You are required to initiate that within 1 year of your priority date becoming current. And then, yes, you have to show that there is a job opportunity in the United States, because if yours is an employment-based application.
That's it.
That's it.
All right. Setal K is next. I am derivative with AOS pending, having priority date September 2013. What is the drawback by using GC Ead instead of H4 Ead, as H4 Ead is expiring and not seeing approval in another 10 months?
What's great about using the H4 EAD doesn't have the ability for when you file for an extension on your adjustment EAD, you get 180 days where you're authorized to work while that's pending. But with an H4 EAD, you have to have the approval in hand to be work authorized. So it's better to change if you're, on an H4 EAD to your adjustment EAD, so you have that flexibility.
All right, next one from other AA. Can we work on 2 full-time jobs on EAD? One from employer who filed my GC, another for another company. Can we work on 2 full-time jobs on EAD? One from employer who filed my GC and the other for another company.
Well, you can. I don't know how you can do 2 full-time jobs at 40 hours a week. That's 80 hours a week. But if you're on an H-1B, if you work for an employer other than your H-1B employer, your H-1B will no longer be valid. You will have to then just depend on your AOS status. And if anything should happen to your AOS status, you're kind of out of luck.
All right. Next one is Srini Rao. How to handle multiple I-145 filed on Eb2 and Eb3. Protect kid age out. Will get RFE to withdraw one of AOS before adjudication. That's the question mark. Biometric done for Eb2. Will it use for Eb3 also?
Your question is a bit complex, and with anything with CSPA, I like to have more details. Can you email me at info@cellolaw.com with all your documents, your receipt notices for your multiple filings, and your child's age? So what we can do then is come up with a real comprehensive strategy, because I don't want to tell you something without having seen all the documentation. And that way I can help you make sure that you protect your child in the best way possible.
I see another question in the chat. Malvika Shah, we'll take that question in the same order, but please, as we said, we're not taking any more questions today because we like to finish what we have. But please do send an email to info@cellolaw.com. We're glad to reach you soon. Next one is another AA. Greetings, Ms. Challa. A couple of questions. Will I have any impact on my 485 case AOS if I happen to change my attorney to renew my EAD? I got an RFE recently on AOS after 9 months of filing.
Oh my gosh.
Second question, do I need to apply for both AP and EAD, or AP is deemed to be default with EAD renewal?
No, I mean, you have to apply for both separately. And no, there's no problem in changing attorneys, and there should be no reason why, unless the USCIS made a mistake, why your AOS has been RFE'd. But you can change attorneys if you'd like us to help. We'd be happy to. We get that a lot because people have filed with another law firm and they haven't been satisfied with either the feedback or the strategies that law firm is providing. So we do that all the time. We would just send in our new G28 with the response.
Okay. Next one is Abhijit Bobde. Welcome, Abhijit. Who's a new person, new attendee. I have an approved I-140 from my previous employer, Eb2, priority date March 2013. If I go back to that employer, will they need to start with perm or can I concurrently file downgrade and 485?
Can you say that again?
I have an approved I-140 from my previous employer, Eb2,
Okay.
PD March 2013. If I go back to that employer, will they need to start with perm, or can I concurrently file downgrade and 485?
You can currently, and I would file a new petition when you downgrade, not an amended. So you can file a downgrade and a 485 without having to go through perm again. As long as, yeah, and even if they revoked it, if they didn't revoke it, it's fine. Even if they revoked it, you can file a new petition, I-140 petition.
All right.
I think our puppy is having issues with me being.
All right. You want to take care, or you want to continue?
Maybe just a couple of quick questions.
Okay. Setal K, will there be any future issue if myself and kid will be on GC Ead when primary will be on H1 status? I think she asked a follow-up question, I think.
No, that's no problem.
All right. Malvika Shah is on the Q&A. F4 Indian citizen, June 2007. How much time approximately will take? Current adjustment of status 1st December 2005.
Well, the family-based numbers are not moving very fast, so we'll have to wait and see. And that, sometimes that may work in your favor. I mean, I wish they would say, okay, if people can't process at the consulate overseas, let's at least utilize some of the folks that are doing AOS in the US. And I'll definitely bring that up with the Appy 100 group, because that's a very good point.
Well, she said F4 Indian citizen, but in the chat, because she's the same person, I think, is there any possibility the person in US on student visa, can it be possible to do adjustment of status on higher education achievement on US basis?
Yes, there's national interest waiver, there is extraordinary ability, there is outstanding scientist and researcher. Send us an email and we'll send you the checklist or the requirements for those categories. And maybe you're eligible that way.
Okay. Next one is from Kishore. Hello, Lakshmi. I didn't understand it earlier. I have a question for you regarding H1 transfer in future. If I have to transfer to CAP subject employer from CAP exempt with my H1 previously approved with CAP subject employer, could you please answer this question? Do I need to go through the lottery process again? Thank you.
No.
I-140 approved with first employer.
They look to see if you've had an approved H1B subject to the CAP within a 6-year window. So within that 6-year window, because you've already have an approved CAP subject H1B, you're not subject to the CAP again.
All right. Next one is AA. Thank you, Lakshmi, for conducting the webinar, answering immigration-related questions to the immigrant community. I filed my 485 last October. It's a EB2 to EB3 downgrade, new I-140. I have a question about changing job while I-140 and I-485 is pending with USCIS after 180 days of filing AOS. Do I need to wait 180 days from my I-140 is approved before joining a new company, or can I join a new company after 180 days from the filing date?
Right, so it's 3 things. First, your I-140 has to be approved. So try premium processing your I-140 because it was filed in October and November. The USCIS should have the perm by now. Number 2, so the I-140 needs to be approved. Your I-485 has to be pending. So you take the receipt date that the I-45 was received and you count 180 days. And you have to work in same and similar employment. If you do that, then, when you change to your new employer, just file a new I-485J.
Okay. Setal K is following. What will be the no immigration status while using GC Ead? What will be the immigration status while using GC Ead?
If you're on an H4 or an H1B, you can be both a adjustee as well as an H4 or H1B, whether you use the EAD or not. Now, if the H1B uses the EAD for employment other than the H1B employer, then that's a problem. For the H4, they can work for anyone. Theirs is not a, their status is not authorized solely on their employment.
Kishore, thank you very much for your comment on the chat. Appreciate that. Next one is AA. My PD is September 2010 Eb2 India, and 485 has been filed in October 2010. Most likely I will be current in 1 to 2 bulletins. Since visa number need to be used by September, there will be only few months to get the visa number this year before reset of numbers in October. Could you suggest what proactive steps can be taken to ensure the 485 gets processed, as USCIS is taking too long?
Yeah, I would just make sure that, you know, all the information, like, for example, if you didn't submit medicals, I would make sure you proactively send your medicals in. If you've changed employers, submit your I-485J. You could also, just to make the process quicker, because I know that we've had people get RFEs saying, are you still working for your I-485 employer? Maybe even having them get a confirmation of employment letter and submitting that to the USCIS so there's no delay.
I got 3 more questions. Next one from AA, and the only thing that there says public charge with a question mark. I don't know what that means.
Yeah, public charge is in a flux. If you email us at info@chellalalaw.com, I think Mac posted our YouTube video on public charge. Or you could, you know, email us. I know that we've, that's why I say connect with us on social media, because I know that we've posted a number of articles on the changing, evolving public charge issue. So please feel free to do either. Look at the YouTube video and then email us and we'll send you the latest update.
Kishore is saying he asked 2 questions, but I only answered 1. You answered 1, but I think Kishore, I've whatever I see at 12:43, I did ask, but again, you know, send us an email to info@chellalalaw.com if you think, you know, we didn't answer completely. Be glad to get you the answer, you know. Thank you. Apologize for that. Next one is series. Can you please share the working woman group details? Wow.
Yes, I will do that next week. And specifically, it's, you know, I decided to put this together because I have written some articles and I've spoken to groups about, you know, how to juggle the many parts of yourself while you're trying to balance home and work life. And I can say this just because culturally it's different for Indian women. No matter what they're doing, there's certain expectations that, you know, in the traditional roles as the country is evolving to kind of keep up with more women in the workforce now. So I'll have that information next week, and I hope that I can be a resource, and I'd love to talk to people that are dealing with this. I think it's really important to have a community to, you know, to get best practices together.
All right. I see. I said earlier, Kishore posted 2 questions. I'm sorry. It says Kiran Gunturu, and I don't see any question from Kiran Gunturu at all with that name, unless you posted under AA.
Kiran, just
Kiran-
go ahead and email us
Yeah,
whatever
please.
question it was that we didn't get to, and we'd be happy to do that.
Yeah. Next one is from AA. If a negative decision is made on 485, can I use the I-140 pertaining to that 485 to file for a H-1B? On the other hand, what options would I have?
Yes, you can. And then, if you think it was filed, it was denied incorrectly. I mean, if you get it, they're not going to deny it summarily. They'll only deny it after an RFE. And if you get an RFE, like I said, if you want, you can always change change lawyers, or you can even send it to us and have us take a look at it. But they're not going to deny it immediately. They will issue an RFE, and that's when you've got to make the decision. Do you want this lawyer who's gotten the RFE to continue, or do you want to use somebody else? So,
All right. The person who was asking about public charge it says, does it stop me from filing for work authorization after filing asylum? That's what his question.
no.
All right. Last question. Ram Chandra, who's asking a follow-up question. Thank you for answering my earlier question about EB3 485 filing, company A merged with company B. Can we still file I-140 amendment now as actual 485 filed in October 2020?
Yes, yes. And if you do that with a new attorney, at least you can say that it would have been filed earlier, but our previous, legal representative did not advise us to file it. And so that's an excuse you can use for the delayed filing.
That's about, folks.
Well, it was great connecting with everybody. Remember our contest. I'd love to spend 30 minutes of chai time with you, with a mug, with some Starbucks, and we can talk about anything you want. And, make sure to look out for our webinar next week. I'll have information about our women's group, but I'll also be addressing some of the latest perm cases. These are either perm cases or adjustment of status denials, all denials on perms, I-140s, and 485s. What are the adjudication trends based on these denials is what we're going to be dealing with next week. So if you're worried about your case, you don't want to miss this. I'm sure your friends would really enjoy it, because looking at how the USCIS is denying cases gives you some insight as to how they're going to be adjudicating your petition. So these are tools. Remember, that's what we provide. Tools so you can be successful on your immigration journey. Thank you for joining our community. Thank Kara and Mac and the entire team for putting this together. Thank you, Shekhar Challa, for being our moderator and doing such a great job.
Thank you for the opportunity, Lakshmi. See you later, and see you all, everybody. I hope you're watching IPL. Go Sunrisers.
Take care. Bye-bye.
Have a good afternoon.